Good morning. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is November 14th, 2018. The time is 9:30. With us today are Commissioner Emily Lindley and Todd Berkey for our General Counsel's office. I'm John Neerman, and Mr. Berkey, I'll ask you to begin the proceedings.
Certainly.
Good morning. Item number 1 is the consideration of the proposal for decision and proposed order concerning the enforcement action of INU USA Inc., DBA Little Elm Gas and More. The ALJ is not in attendance to present as PFD, which recommends that the Commission impose an administrative penalty and corrective action against the respondent for 3 UST violations. The order of presentation for the party should begin with the Executive Director, followed by the respondent and OPIC. The Chief Clerk's Office agenda-setting letter provided each of the parties with 5 minutes of oral argument time. The ED may save some time for rebuttal because he bears the burden of proof. And we currently don't have anyone signed in for the respondent. So with that, the Executive Director.
Good morning.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. On behalf of the Executive Director in this matter, I am Clayton Smith with the Litigation Division. With me this morning is Lonnie Gilley with the DFW Regional Office. This enforcement case involves an underground storage tank system that is owned and operated by respondent. The ED alleges respondent failed to provide release detection for the system's pressurized piping and failed to report and investigate after its inventory control records indicated a potential release from its system. After the ALJ's proposal for a decision was issued, the ED filed exceptions and respondent filed a response to the ED's exceptions. On October 12th, the ALJ issued his exceptions letter and sustained most of the ED's exceptions, finding respondent committed each of the alleged violations and recommending the ED's proposed corrective action. However, the ALJ is recommending a reduced penalty based on 2 points where he disagreed with the ED's recommended penalty. First, the ALJ found no evidence of any costs avoided by respondent. And second, the ALJ found that respondent's failure to investigate should be considered a single event rather than a continuing violation. The ED respectfully disagrees with the ALJ on this second point and contends the penalty was properly calculated as a continuing violation. As the ALJ found, this violation involves a potential release under the penalty policy. The penalty policy specifically lists unauthorized releases in its examples of continuing violations, and Table 8 of the policy clearly allows potential releases to be considered continuing violations. Additionally, the ED offered testimony regarding the carcinogenic effect of gasoline and the significant harm posed by a release in any amount. There are thousands of underground storage tank systems in the state, and TCEQ relies on regulated entities to monitor their systems and timely report and investigate any potential releases. If a potential release is not timely investigated, then human health and the environment may be exposed to these harmful substances for the entire period until it is investigated and confirmed. Therefore, the ED respectfully requests you approve the ALJ's proposed order as modified by the ED's exceptions, but with an assessed penalty of $29,625. We are here to answer any questions you may have and would like to reserve the remainder of my time for rebuttal if necessary.
Thank you. Commissioner Lindley, any questions for staff?
Not this time. Yes.
Okay. Ask the respondent to approach.
We don't have a respondent signed in, so I think we can move to the
Okay.
OPIC.
Mr. McWhirter.
OPIC supports the executive director's position in this matter. We agree with findings that all 3 cited violations occurred, and we recommend sustaining the ED's exceptions regarding the applicability of Chapter 334 release detection requirements for pressurized piping. We also support the ED's position on the penalty calculation for failure to conduct an investigation. On this policy question, we were persuaded by the ED's reasoning why it is appropriate to consider the failure to investigate as a continuing, ongoing violation. So for those reasons, OPIC recommends approval of the PFD as modified by sustaining all of the ED's exceptions.
Thank you. Appreciate that. I'm not sure there's anything to rebut, but do you want to take an opportunity?
We have nothing further.
Thank you. Commissioner Lindley, I have really no basis to disagree with the ALJ's conclusion that there have been 3 violations. And what are your thoughts?
I would agree.
What
Go ahead.
I was going to ask you, what are your thoughts about the penalties?
Which numbers are you looking at comparing the
Well, I think what's at issue is whether we follow the ALJ's recommendations or the recommendations of staff and OPIC.
And staff, what's your recommendation at this point? 29,625?
That's correct, and that penalty does not include any avoided costs.
So the difference is 29,625 or 29,700, 29,
Yeah.
29,700. Is that
The difference is in dollar amounts
Mm.
is not insignificant. We're talking about roughly 29, 28, nearly $30,000 as recommended by the executive director and OPIC, and close to half that amount, 16,200.
Yeah. No, I support the executive director and OPIC's recommendation.
Yeah, and I think I have to agree with that. Those are really the outstanding issues for me, other than some non-substantive clarifications, which can be gathered up in a motion.
I would agree.
I'm ready to entertain a motion.
Okay. Let's see if this one's rather long since there's a lot of cleanup, so. I move that we adopt the ALJ's proposed order with the following modifications. Incorporate the changes recommended by the ED's exceptions, section III.1, what's it? .3, .4, .5, .7, .9, and .10. Is that clear enough? Okay. And agreed to by the ALJ's reply. I move that we sustain the ED's exceptions concerning violation number 1 agreed to by the ALJ, but incorporate the ALJ's recommended modifications listed on pages 2 through 4 of the ALJ's reply, except in renumbered conclusion of law number 15 and ordering provision number 1. Add the following new finding of fact number 18.f to state the base penalty amount should be decreased by 10% based on the respondent's compliance history. Incorporate the changes recommended by the ED's exceptions in section III.6 and change the penalty amount to $29,625 in renumbered conclusion of law number 15 and ordering provision number 1. Does that capture everything you were?
With that motion pending, my math worked out just a little bit
Okay.
differently. So let me
That's fine.
confer with my mathematician. That is very close to what I have.
Okay,
And-
what do you
And I
have?
understand the basis for how you got to where you got.
Okay.
And I support that. So the motion has been made. I second it. All those in favor?
Aye.
Aye. Motion carries.
Item number 2 is the consideration of the gifts and donations of $500 or more in value given to the commission. And we have Beth West approaching to present this item on behalf of the executive director. We currently don't have anyone interested signed in for this item.
Good morning, Mr. Chairman, Commissioner Lindley, General Counsel, and Public Interest Counsel. For the record, my name is Beth West of the General Law Division, representing the Executive Director. Before you are the gifts and donations received by the agency within the past 90 days, generally speaking from June through mid-October of 2018. In accordance with Chapter 575 of the Government Code, the Executive Director has accepted these gifts and respectfully requests your acknowledgement of these gifts. As always, let me know if you have questions.
Thank you. Any questions?
No, sir.
Mr. McWhorter?
OPIC recommends approval of the resolution acknowledging acceptance of gifts and donations as presented by the executive director.
Yeah, I think that's appropriate too. I do want to take a moment to thank HEB for their continued partnership and support of the Take Care of Texas program.
I agree.
I think the items here are appropriate and would support approval.
Great. I move that we approve the issuance of the resolution that acknowledges the Executive Director's acceptance of the gifts and donations contained in the TCEQ Interoffice Memorandum to the Commissioners dated October 26, 2018, with the caption of docket number 2018-0793-MIS.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries. Thank you.
That brings us to items 3 through 27, which make up our enforcement docket. And program staff, on behalf of the Executive Director, will present this item. We currently don't have any individuals signed in on this item that have requested to address the Commission or not.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Brian Sinclair, also of the Enforcement Division, and Gitanjali Yadav and Janice Hernandez of the Litigation Division representing the Executive Director. Pending before you are items 3 through 27. The total assessed administrative penalties are $284,559, with $39,056 deferred, $75,753 applied toward supplemental environmental projects, and $169,750 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
I don't have any questions. Commissioner Lindley?
No questions.
Mr. McWhorter?
My office reviewed these items, and we recommend approval of the proposed orders as presented by the ED.
And I've reviewed these items as well and think it's appropriate to move forward.
I agree. I move that we adopt items 3 through 27 as recommended today by the Executive Director.
The motion has been made. I second it. All those in favor say aye.
Aye.
Motion carries. Thank you.
Item 28 is a consideration of the monthly enforcement report, and program staff will remain to present that item.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me is Brian Sinclair of the Enforcement Division and Gitanjali Yadav and Janice Hernandez of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2019 through September. There are 106 effective administrative orders issued, and of those, 17 contained supplemental environmental projects. These orders assess a total of $1,149,177 in penalties, with a payable amount of $651,923. $234,662 are to be paid towards supplemental environmental projects. 1,120 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 88 enforcement action referrals have been received. There are 1,569 pending administrative orders, with 118 cases that are on the backlog. 219 cases are pending at the Attorney General's office for representation in district court, and no judgments have been issued. 2,130 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2017, 18, and 19. We are available to answer any questions you may have.
Thank you. Any questions for staff?
No, sir.
Mr. McWhorter?
I appreciate the report. I don't have any questions either.
Yeah, thank you again for all the good work on this. Appreciate it.
Items 29 and 30 are the consideration of the petitions for rulemaking filed by Beneficial Land Management, LLC, requesting revisions to 30 Texas Administrative Code, Chapters 332 and 312, concerning composting and sewage sludge operations. BLM is a moving party and should present the matter, followed by any interested persons, the Executive Director, and OPIC. I recommend limiting the parties to 5 minutes for their presentations. We have one individual signed in who has requested to address the Commission after BLM. So with that, Mr. Birch.
Good morning, Commissioners. Mr. Murphy. My name is Eric Birch. I'm here on behalf of Beneficial Land Management, or BLM, which has filed a petition with the TCEQ to allow the composting of domestic wastewater sludge processed with grit trap waste. BLM has made this petition because this process is beneficial, it's safe, it advances the legislative goals of recycling, and it also helps the TCEQ meet its recycling goals as set out in a recycling study on the economic impacts of recycling. Now, BLM actually engaged in this process for a while until it received, until its customers, 4 of its customers received letters from the TCEQ in April of 2016 informing those customers that the composting of this material was not authorized because it was mixed with grit trap waste. So it was therefore very surprising to see the ED's reasons for recommending denial of this petition, because the ED is essentially saying that this grit trap waste material is not a prohibited waste in Chapter 332, and therefore the ED can authorize, currently under current rules, the composting of sludge mixed with grit trap waste. However, this is contrary to everything that BLM has experienced in dealing with TCEQ on this matter. As a matter of fact, in the spring of 2017, when this commission considered BLM's land application permit, which we'll talk about at the next item, and the commission decided the rules didn't support that. In August of 2017, the TCEQ's enforcement division sent a memo to all of the SOS, the BLM companies, advising them, first off, that the land application of the materials, the grease and grit trap waste, was not authorized. But then specifically, and I'll read this, the generated waste mixture, including the grease and grit trap waste, must be disposed at a landfill due to the presence of grit trap waste, which is not authorized for composting. Now, that also is this position the ED is taking in this Chapter 332 composting proceeding is also directly contrary to the positions taken in the next proceeding that's on the agenda today. In the letter on that matter, the ED says, grit trap waste is not listed as an acceptable compost feedstock under Chapter 332. Quite simply, you can't have it both ways. On this docket, the ED is saying it's already authorized. On the next docket item, the ED is saying it's not authorized. Now, the legislature has mandated the TCEQ to encourage and consider recycling activities. What BLM is proposing here advances the state's goals for recycling. Also, in 2017, in July of 2017, the TCEQ received a study that it initiated on the economic impacts of recycling. In that study, it found that there are millions of tons of materials that are not recycled in the state that could be recycled, and sludge was a big part of it. And what that study also encouraged was that recycling should be encouraged in the state through new markets and through new businesses that are willing to engage in recycling activities. In the ED's response to this petition, he has identified no adverse impacts whatsoever of this practice. And so for this reason, we request that you approve BLM's petition, that you do not follow the ED's recommendation. I'm available for questions.
Thank you. I don't have any questions at this time. Commissioner Lindley?
Not this time, no.
Thank you.
I'd also like to recognize Angela Mormon is here on behalf of BLM. Up next, we'll have Helen Gilbert, representing Gilbert Wilburn PLLC.
Good morning.
Good morning, Chairman, Commissioner, General Counsel. I'm Helen Gilbert with the law firm of Gilbert Wilburn. My law partner was the engineer who wrote the rules originally in 1995 when they adopted the 503 rules. I was just a lowly staff attorney at the time, fielding questions along with Anthony. Sorry, I've dated ourselves. Since that time, I've represented a variety of recyclers, metal and aggregate, sand recyclers, composters, mulchers, dairy waste, sludge, septage, construction and demolition debris, you might say the whole gambit. I'm here to address policy questions because I think it's important to know where we've been in order to know where we should be going with respect to this petition and rulemaking in general. I want to address two specific comments that the ED made in his response to the BLM petition. First, on page 4, the executive director complains that the process isn't innovative enough. This commission has been empowered since at least 1995 or earlier to authorize and approve innovative technology through regulatory flexibility orders and other mechanisms. In the interim 23 years, I think the legislature has only added to your legal authorization to embrace innovative technology, including waste solutions. How are you doing on that count outside of the AIR program? I'm really not sure. The whole purpose of this framework is to encourage people who can build a better mousetrap to do so, and not to use the rulemaking process or to use the current rules as a roadblock. If the rules need to be amended in order to facilitate the innovative technology, then amend the rules. Short of filing petitions on recycled paper printed with soy-based ink, again, how is this commission doing? As Mr. Birch pointed out, this commission has had, the state of Texas has had a 40% recycling goal since 1989, I believe, 1991, excuse me. I think at the last MSW Advisory Council survey, we're right around 18%, so we could do better. And of course, the statewide preference also has been set out in 361.022 since 1989, stating the preference for land application and other recycling over landfilling. On page 5 of his comments, the executive director also complains that in order to go forward with this petition would be significant investment of resources. It would affect something like 101 other regulated entities. Well, as you may know, the ED held a stakeholder meeting about a year ago and has been working on his own rulemaking package to rewrite Chapter 312. That has been characterized in public meetings as just a rule rewrite, a clarification, an update, if you will. The issues that we've seen discussed in that rulemaking are really very, very significant, substantial changes to the rules that would change 25 years of interpretations of these 312 rules. So if the executive director is worried in this petition about the ripple effects on 101 other regulated entities and the significant resources that it would take, then I want you to hold their feet to the fire when they come back in a couple of months with their own rule package. The regulated community needs and deserves consistency, and we request that if you decide to deny this petition, that you will take into account the significant resource issue and the ripple effects that will result as a consequence of the other rulemaking that is coming your way shortly. I'm available for any questions if you have them. Thank you.
Thank you. Any questions?
No, thank you.
Thank you.
Mr. Tetu?
Good morning, Commissioners, General Counsel. Anthony Tetu, Lilly Staff Attorney on behalf of the Executive Director. I'm going to have Mr. Perez will present for us.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. My name is Mario Perez with the Waste Permits Division, and with me is Anthony. Before you today for your consideration is a petition for rulemaking requesting the Commission to amend 30 Texas Administrative Code, TAC, sections 332.2, 332.3, and 332.41, which are compost permit provisions regarding definitions and feedstock materials. The petitioner proposes to add grit trap waste and industrial solid waste as compost feedstocks under a new definition for domestic sludge, along with new definitions for domestic wastewater and grease and grit trap waste. Staff respectfully recommends denial of the petition for the following reasons. The addition of grit trap waste as a feedstock under a compost permit is not necessary since it is not listed, it's not a listed prohibited material in rule. Grit trap waste is typically not proposed by operators as a feedstock since it has no nutrients and requires testing for additional constituents. The addition of industrial solid waste as a feedstock conflicts with existing definition for municipal solid waste, which allows the acceptance of non-hazardous industrial solid waste. The proposed definitions for grease trap waste, grit trap, and grit trap waste are redundant since grease trap waste and grit trap waste are currently defined per Chapter 330 and include the interceptor and sources for each waste. The proposed definition for domestic sludge and domestic wastewater are unnecessary since sludge, as defined under Chapter 330, includes all solid, semi-solid, or liquid waste generated from municipal commercial, or industrial wastewater treatment plants, and the terms that are applicable to compost permits. We thank you for your consideration, and we're available to answer any questions you may have regarding this rule petition.
I do have a question. How do you address Mr. Birch's concerns about having it both ways?
Thank you for that question. I'd like to clarify what seems to me a misconception about what is not acceptable and what is prohibited. During the compost creation rules in the mid-1990s, listed prohibited materials were hazardous or pesticides. They're not compostable, and according to EPA, those were listed prohibited. There are materials that are unacceptable because they're basically not cost effective, they have no nutrients. Those were not listed as prohibited, but they were identified as unacceptable. Grit trap waste, along with water treatment sludge and contaminated soil, petroleum soil, were identified as materials that were unacceptable for composting. And in response to comments during the composting rules in 1995, those were addressed in the preamble as being unacceptable compost feedstocks, but not listed as prohibited. So as a little background, we have 8 composting permits, maybe 9 now. None of them accept grit trap waste. We had one that proposed it, but the testing for the constituents in grit trap waste sometimes can be cost prohibitive. We're talking about testing for benzene and toluene, ethylbenzene, and xylene. Also T-clip to ensure that it's not hazardous material. So in effect, that is basically why we consider compost material to be unacceptable but not prohibited.
Okay, I appreciate that. And just let me try to restate that and see if you agree with how I'm understanding it. So a feedstock or a waste that's unacceptable is not the same as being prohibited. Prohibited is just flat out prohibited in all cases. Grit trap waste could be acceptable or not acceptable, but in order to be acceptable, it would likely have to be subjected to a fairly rigorous testing regime, which you think is maybe economically not viable. Am I getting it?
I would say that's correct, yes.
Okay, appreciate that. Commissioner Lindley, any questions for staff at this time?
You asked the one question I had, so I appreciate that discussion. I don't have any further questions right now.
Thank you. Mr. McWhorter.
OPIC agrees with the Executive Director's recommendation for this petition on Chapter 332. We support the ED's findings that the proposed changes either conflict with or are not in harmony with other defined terms and requirements for composting feedstocks. And I appreciate that clarifying question because I had the same question, and I think that just validates the position that I have, so I appreciate that.
Thank you for that. I'd like to ask Mr. Birch I'm going to allow you a few more minutes to speak to 312 a little bit more.
Okay, well,
directly.
and I can do that now, or we can just move into 312 if you'd like to do that.
Let's do
I
that.
would like to make a couple of real quick clarifications. You know, the prohibited but not acceptable, it's almost like that distinction without a difference sort of a thing. It's basically saying you can't do it. The other thing, important distinction here is we're not talking about composting grit trap waste. We're talking about composting sludge that's been processed with grit trap waste.
Right.
And the reason that's important, I can mention here as we're talking about the 312 rules. So
Yeah, and just to be clear, we had both of these petitions teed up under the same item.
Okay, well, great. So we're on the record then for the 312 rules
We are,
right now.
yes.
Okay, great. Again, Eric Birch on behalf of BLM. What BLM has proposed in this petition is the land application of sludge that has been processed with grease trap waste and grit trap waste. Again, this process is beneficial. It is unquestionably not harmful. It advances the state's recycling goals and helps TCQ meet its economic impact recycling goals as set out in its study. BLM has had this practice in place for over 10 years. The ED has, there's a difference of opinion about whether the ED approved it or not after reading through all the materials that the ED provided in his response. However, early on and from the regional offices, this practice was continually recognized and approved. There were no violations issued for this practice for years. The ED, for reasons that are still unclear to BLM, is clearly opposed to this practice. We understand his position. We don't know why. Before the petition, the ED argued that the rules didn't support this. That's how we ended up at the agenda meeting in the spring of 2017, where that question was teed up. The commission decided that the current rules of TCQ did not support that practice. But in an exchange between you, now Chairman Neerman, and former Chairman Shaw, there was a discussion about the practice might have benefit, but you just didn't believe the rules supported it. And encourage BLM to go to change the rules if we felt like that's something that needed to be done, if we felt it had benefit. And so that's what we're here today for, is we're here to change the rules as discussed by the commission. The other thing that's really important here is that that decision by the commission that day really torpedoed BLM in every respect. We were all set to go to a contested hearing where in the evidentiary process we could prove that the rules actually do support it, and we could also prove the benefits of the process. But that one decision by the commission basically undermined the entire process, and then as I mentioned, the 4 letters that the ED issued and then the subsequent letter in August of 2017 completely shut that business down. BLM had no options. The ED basically mandated all the materials be landfilled instead of being recycled. BLM ultimately sold their business. They're out of business now. Now, BLM, the actual land application site is still owned by the Mayfields, who owned all these companies, and they're still interested in doing this and still believe it's a recycling program that should be encouraged and used in Texas. Now, before today, as I mentioned, the ED said the rules didn't support it. Now that we filed the petition, the thing that is just confusing is the ED is still saying the rules don't support it. Well, that's what this is all about, is to change the rules. Now, I don't know if the ED is talking about the EPA's rules, but the EPA's rules clearly support it. They're very open to this kind of practice. States around the country do this sort of thing, so EPA does not prohibit this. So it's TCQ's rules we're talking about. And the ED spent a long time explaining why the rules don't support this. Didn't understand that whole argument because we're here to change those rules. That's what we're asking to do. The other thing the ED said we don't understand is the ED said that they don't believe BLM's data. BLM did studies, submitted all that information to the ED, and the ED now says they really don't believe what we did. Well, it was the ED study. The ED designed that study. When we were having these questions years ago, the ED said wanted more proof this process was not harmful and the benefits of it. The ED, we asked, what do you want us to do? The ED designed it. And that study proved unquestionably no impact, not just a little, no impact. The results were pretty unbelievable. I mean, thousands of samples. Between TCEQ and BLM, surface water, groundwater, soils, everything was tested. And it was just basically all clean, nothing there. The ED has also claimed that maybe the material's not beneficial, and I think part of this is suggesting that maybe the grease and grit trap component is not beneficial compared to the sludge itself. Well, first off, again, BLM hired an independent agronomist. It's not BLM's data. The ED wanted independent data. We've got a Texas A&M expert agronomist who did the study.
That's 5 minutes.
Just ask you to wrap up.
Okay. Well, anyway, he concluded that this was beneficial. Also, the ED has suggested no treatment occurs. The innovative process that BLM has developed basically uses the same process in a wastewater treatment plant to treat the grit trap and grease trap materials, which would, as we've discussed in the past, mechanically that material damages a wastewater treatment plant. That's the reason that material is taken out. The Mayfield's BLM has figured out how to apply the same biological treatment, bugs, that treat that material without damaging the equipment. You know, I guess in a real quick wrapping up, you know, I've been in so many public meetings where the neighbors are upset because of something TCEQ is approving, and TCEQ goes back to science. They go back, TCEQ says we are a scientific agency, we follow the science. That is not being done here. The ED is not following science. The science is clear. The process is beneficial. There is no harm. Don't know whether it's fear, politics, or whatever, but science is not prevailing here. So we ask you today to let BLM move forward with this innovative process and continue this recycling effort in Texas. Thank you.
Thank you. I do have one question. I think there could be a difference between the operations that BLM had been running and on which quite a bit of data was collected, and other operations that might be authorized under the kinds of rules that you proposed. And so I'm concerned really about the origins of the waste stream. So, for example, how do you ensure that you don't have high levels of benzene or toluene or some other undesirable contaminant in a particular batch of grit that gets picked up and mixed in with the product? Not at BLM's operations, let's set that aside, but how would a rule protect against that from some other operator anywhere in the state?
Well, I think there's two responses to that. One is, remember again, the material that's going through those grease traps is identical to the materials that's going through to the wastewater treatment plant. Now, it may be different levels of it because you're dealing with solids that have collected in a trap, but chemically, the same materials. The trap is not prohibiting any of that material from going into the wastewater treatment plant. And the second thing is, there are performance requirements. BLM was required to sample the incoming grit and grease trap materials. Routinely, they found the materials were well below the levels of concern. But the way to protect against that is simply to set, that's what we're asking to do, is to work with the staff to come up with the right testing frequency, the right parameters, those sorts of things that can protect the incoming grit trap waste. But also remember that material, just like it's going in a wastewater treatment plant and being biologically broken down, well, the same thing would happen through this process, through BLM's process.
Okay, I appreciate that. And I'll just share an observation. I mean, it seems to me, I'll give you a chance to respond to it, I guess, to be fair. It seems to me that water coming off of those traps, and I meant to say grit traps, that's really a greater concern about the grit traps than the grease traps, but the water coming off of the top of those is going through a treatment process, whereas the residuals, the actual grit trap waste itself, is being mixed back in after the sewage has gone through the treatment process.
Yeah, and that, I think, is the entire kind of fallacy of this whole thing that's confusing. When the incoming water comes into a wastewater treatment system, the water comes in, activated sludge is remixed with that incoming water, and that's how the biological treatment occurs. BLM is taking activated sludge outside of the wastewater treatment plant and mixing it with the grease and grit trap waste in a tank, and the same process is occurring. It's the identical thing. The biological, the bugs are coming into this material just like it's going back into the other material. The other thing, let's not forget, a lot of states are doing this. In our survey, we've looked for other states. We couldn't find any states that prohibit this. Okay, I'm not saying there are none out there. We couldn't find any. We found other states that do authorize it. And we found EPA's rules do not prohibit it at all. So it's baffling to us that Texas will not allow this process where other states around the country do allow it, and they're getting the benefit of it. And again, look at the performance data. There's no harm, zero. So I understand your concerns, Mr. Chairman, that maybe you have these materials, but after 10 years of practice, we haven't found that's a concern.
Appreciate that. Any questions from
Just
Mr.
a quick
Birch?
question. How many states out there are doing this? Who is it? Who's doing it? Or
You know,
allowing it, I should say.
Believe it or not, it is very difficult to find out. And part of it is because different states call this stuff by different names. You know, we call it grit trap waste, others call it like car wash facility waste. We've tried to find that answer. We don't know how many states are out there that do it. Because it's just, you do these searches, and like I said, we did it two ways. One, finding places that don't allow it and other places affirmatively approve it. Most, they're just kind of, there's nothing. And then, but we found places that approve it and none that have prohibited it.
I'm confused by that.
Yeah,
So,
the answer is I don't know how many
you say
sta-
states allow it, but then you can't say what states do, and I just want to get clarification.
Minnesota allows it
Okay.
affirmatively. North Dakota allows it affirmatively, which those are unusual too because they're way up north. And you would think if anyone was concerned about this material being land applied and absorbed into the soils and all, it would be a cold climate. And they both do approve it.
And then you said some states prohibit it, or?
None that we know. We haven't found any. I'm not saying there are none.
Yeah.
We didn't find any.
Okay. Thanks. That's all I have.
Thank you, Mr. Birch.
All right.
Appreciate it. Staff, I'd like you to address 312 generally, but also the question that I posed to Mr. Birch about how do you catch these contaminants that might be mixed in with a particular batch of grit trap waste.
Thank you, Chairman. Once again, for the record, Anthony Tatu on behalf of the Executive Director, and we've been joined at the table by David Galindo, Brian Sarant, and Paul Askanaski from the Office of Water. So I'll ask Brian to address that.
Good morning. The grit trap waste is usually collected at the headworks of the plant, and I'd say in this situation for this particular plant, what we're seeing is a unit where the grit trap waste is pumped directly into the tank, grit trap and grease trap waste, and mixed with the sewage sludge that's already been treated through the system and hit with air and dried. We don't see that with any other kind of treatment facility that we're aware of. And I would say that, that's, if you want to help me with that,
if I may. For the record, I'm David Galindo, Director of the Water Quality Division. So the rules in 312 were based on EPA's 503 rules to authorize land application, beneficial reuse of domestic sewage sludge removed from a domestic wastewater treatment plant. In collection systems, there are interceptors or grease traps as well as grit traps that keep that material from entering into the collection system for the reasons that Mr. Birch mentioned, protecting the plant.
Can you just give me an example of where those grit traps might occur? I mean, they're local to facilities, car washes, but they also are at the receiving end of a wastewater treatment facility, I imagine.
Yeah, and so there is going to be grit that gets into the collection system, and so as Brian mentioned, at the very front end of the system is a grit separator to prevent that any material that made it into the collection system from being removed. So you'll see grit traps at car washes, mechanic shops, and so they do collect. So they're designed to collect those hydrocarbons, oil, petroleum-related waste, and capture those. That's typically handled as a special waste under the waste regs, and so it's got a process, or there is a process, a mechanism for disposing of that material. There's been a lot of discussion of grit trap waste and grease trap waste, particularly about other states authorizing this. And so the majority of the other states that we've looked at may have some allowances for grit trap waste. For grease trap waste. There are some studies out there that show that domestic sewage and grease trap waste, when land applied, still result in, so you're still getting a crop yield out of that mixture. The grit trap waste itself, I'm only aware of one state that allows grit trap waste. And I don't know if that's combined with domestic sewage sludge or if they're just authorizing it for land application. But the issue with the grit trap waste is that in the studies that they had, more of a demonstrations that they had put together under their, wasn't actually under their permit. They've never had this authorized under a wastewater discharge or under a wastewater beneficial use permit. Their authorization to do this was under a compliance agreement. And so the agency had included additional parameters within that compliance agreement to ensure that there was no accumulation of any of these materials. And so it was more of a monitoring exercise on behalf of the agency to ensure that what they were doing was protective or was not resulting in any contamination to surface waters or groundwaters. And so where we end up with on the grease and the grit trap waste is that their study that they had done, the demonstration, really didn't identify or separate land application of the materials to demonstrate that what they were getting was not similar to what they would have gotten just with the nutrient value of domestic sewage sludge. And so there's not really the data that was provided doesn't show that they're getting any beneficial use out of it.
Why is that important? Do you have to receive some measurable benefit from every molecule that's applied, or how do you slice that, and why is that important?
Mm-hmm.
The beneficial use piece of it.
So I'll let our agronomists talk about what the values that you get from domestic sewage sludge.
Good morning, Commissioners.
Morning.
Paul Askenazi, Water Quality. The application is for beneficial use, and beneficial use looks at nutrient values of the material. In the case of sludge, it's nitrogen and metals. So whichever one is goes beyond a ceiling level for metals, is generally based on nitrogen. The testing that was done in the field, the demonstration plots, looked only at, didn't look at the nitrogen content for beneficial use. So it looked at VOCs, and but that's pretty much what they looked at, and grease, oil and grease.
All right, I appreciate that, but I think my question was more about if anybody has an answer for it. I'm still scratching my head about this one, but an answer to really the policy question. Why, as a policy matter, or perhaps as a legal matter, why does every molecule that would be land applied, every molecule, for example, grit molecules, have to have a beneficial impact? Why can't some molecules just travel along with other molecules that are having a beneficial impact? And so that's one question, separate and apart from my concern about what undesirable contaminants might be traveling with those molecules. Let's assume that these are not harmful molecules, but perhaps not beneficial molecules.
Mm-hmm.
Am I making sense?
Let me see if I can
Okay.
answer your question. So the test for beneficial use is, I think the definition is that you're applying a product that has some nutrient value or that is applied under the crop's needs for that nutrient value. So you're not over applying nitrogen. As far as other molecules, potential pollutants, you're going to have those other things as well in domestic sewage sludge. When the 503 rules by EPA, when those federal regulations were developed, they did a survey of different facilities and looked at the sludge that was generated at those facilities and did a extensive testing on what parameters were also present in that sewage sludge and how the fate and transport of that material once it's land applied. And so the rules were all designed around that domestic sewage sludge coming out of those systems. In our response or in our recommendations, we mentioned how EPA handles commercial septage. Our interpretation of what the petitioner was arguing was that this material is essentially domestic sewage sludge, even if you add it at the end of the process. And so when you look at some of the guidance documents that EPA had provided, the definitions of sewage sludge include domestic septage. They were very clear about commercial septage, grit trap and grease trap waste not being domestic septage and not being part of that, what was included under 503 for land application.
Yeah, appreciate that.
Could I just add one comment? And I really feel like this is the entire crux of this issue that we've been going back and forth with BLM for a long time, which is if the grit trap waste isn't adding any nutrient value and is being land applied, essentially what that is just surface disposal. And that's really what we've been going back and forth about for all this time. And that was to address your first question about what harm it is.
Appreciate that. Commissioner Lindley, questions?
I don't believe so. No questions at this time. I'd like to hear from Vic.
Mr. McWhorter, respond to anything you've heard, but include whatever observations you have on 312, because I think we missed that last time around.
Yes, I support the executive director's recommendation on this, and I agree with the executive director's reasoning in recommending denial, and that the ED's interpretation of the reasons behind the current interpretation of 312 3D makes sense as applying only to combination of waste occurring before processing within a treatment plant. And I understand the policy questions because it is a valid question about if you're applying something intended to have a beneficial use, does your question about does every molecule need to have benefit? I think that is a policy question. There could be wiggle room within that, but I agree with the ED's reasoning in answering those questions, and I'd support their recommendation for denial.
Appreciate that. Any questions for OPIC?
No, not this time. Thanks, Vic.
Other questions or observations at this time?
Not this time. Do you have some? I feel like
I do.
I'd like to hear from you.
So, as we've heard, these petitions both concern a process that aims to. Mr. Birch, I'll give you just
Mr.
a
Chair,
minute
just as long as I
to
have
respond to what you've heard.
Okay, thank you very much, Mr. Chairman, because there are things here just don't make any sense again. Grit trap waste. Remember, the materials are basically, they're the inert materials that are falling into the bottom of a mechanical trap. The chemicals that everyone seems to be worried about, the hydrocarbons, they float. Most of those things are lighter. They're the ones that are going to go to the wastewater treatment plant. Yes, there's going to be some of it that gets attached to the grit. It's going to go and it's going to be treated. The grit, it's inert materials. You can take grit, you can dispose of grit anywhere. You can use it for landfilling. It's inert material. It's not the problem. It's whatever the other stuff is. The grit is almost a red herring. Grit's just dirt, okay? The other materials that will go and be processed by the activated sludge is the same materials that will be treated by the wastewater treatment plant. The other thing is what we're asking for is a rule petition that will go through the rule writing process and the stakeholders process. What I'm asking you to do today is don't do to BLM today what the commission did to us a year and a half ago. You shot us down without giving us a chance other than this short few-minute discussion and a couple of briefs to prove our case. If we can get the petition filed and we can initiate rule writing, every stakeholder in the state gets to weigh in on this. And the staff will get all the input, we'll get all the data, BLM will work with this agency to do whatever testing is required. But this material, again, all of the things we're talking about, when the agronomist goes out there and samples the soil, there's nothing. The process works.
Thank you. And so just a couple of observations or responses off the top. I appreciate that may be the case with BLM's operations, but I do think that there may be a difference between the operation that BLM is running and others that might be authorized under the rules that you have suggested. And there is as was noted earlier, an ongoing rulemaking on this in this area. So I think that is probably the place to be engaged on this. We've heard about the process. It aims to beneficially use the GG waste material. That's a laudable goal. We've heard about how that process works. It makes sense to me that the bugs that are treating this sort of waste in the wastewater treatment systems don't just go away because you've land applied it, that the bugs continue to work on it. All of that does make some sense to me. The problem that I see is I'm not convinced that that the rules that have been suggested are going to be protective of the environment in every case. Maybe with BLM's operations, but we're talking about operations that may be permitted across the state in a lot of different types of country, a lot of different circumstances, and again, grit trap waste that could vary quite a bit from location to location, and even batch to batch, depending on which mechanic drove his pickup through the car wash that day. And so I like the idea of what the petition proposes. It's compelling, but I just am concerned that the way it's been teed up is not protective. So what we would need for either composting or land application are regulatory controls that are protective in a multitude of different circumstances. And I actually think we have that for composting. It's a case-by-case review. It imposes burdensome requirements, perhaps, in understanding what the characteristics of the feedstock is, but it can be authorized that way. With respect to land application, the current rules obviously don't address the risks of grit and grease trap waste, and as I mentioned, I don't think the way that the petition has been teed up adequately addresses those risks either. So I might pause right there and gather up your thoughts, Commissioner Lindley.
I tend to agree. I completely agree that the commission needs to encourage recycling more in every way possible. I'm just not fully convinced that the rule petition gets us to the safest way to do that, kind of for the reasons you discussed. I agree BLM's operations are, I'm sure they're careful with their product and that they apply it correctly, and they submitted data that says that, but we don't have the data that says that wasn't just sludge doing that. It's a much simpler way, I think, of saying of what you were also saying, that the data is not quite there to show that the grease is contributing, it's beneficial to the land, the grease and grit, excuse me. So at this point, I would be more on the page of denying the petitions today, following the ED's recommendation, but, always encouraging staff to take it serious consideration when we get these, new kind of ways of doing things, to take a hard look at them. And I believe staff did. I mean, they've been working on this for years, just to make sure that we are, looking at what the best new options might be out there. But at this point, I'm on the page of denying the petitions today.
And that's where I come out as well on both petitions. And just to be clear, for purposes of a motion, I would deny the petition on Chapter 332 because there is a mechanism in the rules to authorize this waste. In other words, to make it, it's not prohibited waste, but to be able to get over the hurdle to make it acceptable in the composting context. And for purposes of the motion, I would deny the petition because of the environmental risks that are posed by land application of untreated GG trap waste. Did you have any other bases, or do you want to
No, sir, I believe that,
go with
that's all I would say as well.
go with those?
Mr. Chairman, can I ask one clarifying question?
Sure.
There's still this big contradiction because, this document yesterday or from the 5th says grit trap waste is not an acceptable compost waste material. So could we ask for some sort of a clarification document or policy from TCEQ? Because I keep hearing that it can be done for composting, but we've got documentation clearly saying it cannot be done from the ED. So something needs to be clarified on that.
Yeah, as a separate matter, I'll be happy to take that up. But just real quickly, my understanding of it is you can get. Maybe I'll ask the ED staff to tell me if I've got this right or wrong. And I think I stated this earlier. Grit trap waste can get over the hurdle to become acceptable, but it's going to have to meet a pretty rigorous test to make sure there aren't any undesirable cats and dogs mixed in with the grit trap waste. Is that correct?
That's correct, Commissioner. Thank you.
Thank you.
Well, it says right here, it's not listed as an acceptable compost material for Chapter 332. So, if we can go on the record, but there needs to be something, because our concern is if we try to do that again, we've got, every document I've got from the ED says you can't do it, other than this one response to the 332 rules.
All right. Well, I think we take that up as a separate matter, but for purposes of the petition for rulemaking, I think we're at a point where we're ready to entertain a motion on that. Thank you, Mr. Birch.
Ready for a motion?
I am.
I move that we deny the petitions for rulemaking filed by Beneficial Land Management LLC, which seeks to revise 30 TAC Section 332.2 because the existing rules provide for the end sought out by the petitions, and that we deny the petition for rulemaking filed by Beneficial Land Management LLC, which seeks to revise 30 Texas Administrative Code Chapter 312 because there's insufficient evidence to support a conclusion that the land applied grit and grease trap waste is beneficial to land, and that the petition's approach could result in that land application of untreated grit and grease trap waste.
What I want to capture in the motion is, if it's all right with you, is be a little bit more pointed about the environmental risks that might be presented by the land application. So, can I offer an alternative motion?
Absolutely.
All right, let's try this. I move that we deny the petitions for rulemaking filed by Beneficial Land Management LLC, which seeks to revise 30 TAC Section 332.2 because the existing rules adequately provide for the end sought by the petitions. That we deny the petition for rulemaking filed by Beneficial Land Management LLC, which seeks to revise 30 TAC Chapter 312 because the petition's approach presents environmental risks from the land application of untreated grit and grease trap waste. Does that work for you?
Yeah.
Okay.
That sounds great.
Motion has been made. Do I hear a
Second?
second?
Yes.
Second. Motion has been made and seconded. All those in favor?
Aye.
Aye. Motion carries. Thank you.
Item number 31 is the consideration of the petitions for rulemaking filed by Wimberley Valley Watershed Association to amend 30 Texas Administrative Code Chapter 39 to add requirements regarding notice of internet availability for certain permit applications. WVWA is the moving party and should present the matter. However, there is currently no one signed in on their behalf. So if they are not present, then we would start with the executive director and OPIC. We recommend the parties be limited to 5 minutes for their presentations.
Good morning.
Good morning. I'm Janice Hudson, representing the Executive Director this morning. The Executive Director recommends denial of the petition for the reasons stated in the backup that was filed for this item. Specifically, while the action requested has been implemented for applications for municipal solid waste and medical waste facilities permits, in a similar way for water rights applications, expansion of the requirement for external posting of applications would be a significant change of procedure for the permitting programs to which the Chapter 39 rules apply. Specifically, the Executive Director wants to ensure that applicants would have the resources to comply with the requirement to make their applications, as well as updates to the applications available on a public website. There's a great deal of diversity in the types of applicants for air quality, water quality, industrial and hazardous waste, underground injection control, and radioactive materials permits. For example, this includes municipalities, districts, water and sewer utilities, school districts, colleges and universities, military facilities, large corporations, including refineries, chemical plants, and concentrated animal feeding operations, and small businesses, such as operators of rock crushers, concrete batch plants, agricultural operations, mobile home parks, and small capos. In addition, the volume of applications for the air quality and water quality programs far exceeds the number of applications filed in the programs for which a similar requirement currently exists. And internal management of the information would also need to be considered. The objective of making applications available online for online viewing is best achieved through a process that can be flexible enough to take into consideration the time, resources, and outreach efforts associated with this type of change to the permit application process. The Commission has authority to utilize the electronic means of transmission of information, and the agency is gradually moving toward implementing requirements for applications to be submitted electronically, as well as making those available for public access online. In summary, the Commission is currently improving and expanding public accessibility of certain permit applications electronically, but only after considering information on how applicants are affected by such changes. The rulemaking petitions, which propose changes that will apply across the board for the first time to a broad range of permit applicants for which there is not enough information at this time to determine the potential impact. Therefore, the Executive Director recommends that the petitions for rulemaking be denied.
Thank you. Questions for staff?
No questions.
Mr. McWhorter.
This is a little bit of a tough one for me because I think everyone's on board with the idea of making applications more available electronically, and it's just a matter of how we're going to get there. I think eventually we are going to get there, and I realize that this particular proposal would impose requirements on a whole set of applicants that previously haven't been subjected to that, and the people who currently have to do that under the MSW scheme, is a smaller universe, perhaps with more resources. And I do appreciate that, but I think given my role, it's important for me to point out that the current system of how applications are made available to the public has had an adverse effect on public participation. This requirement that we have from 20 years ago about having hard copy available in a library in a county that may be 50 miles away from where people are, and as laid out in the petition, I mean, we hear it routinely. People will go to that place and either the application cannot be found or it's missing and it's bound and it's hard to copy. So I think everybody realizes there are inherent problems in just relying on hard copies to be available, to the public. But my initial reaction to this was to support the idea of moving forward with initiating rulemaking, but only in the sense of an emphasis on the upfront part of the process and emphasizing stakeholder engagement to get a handle on what these impacts would be to applicants, and also the readiness of program staff in different areas to maybe go a different direction and make the application available electronically. But it seems, I know that this issue may have the interest of the legislature too, so I'm okay with the recommendation to deny for now, with the idea that depending on what happens in coming months, maybe coming back and revisiting the idea of this, and in the meantime, continuing to gather information about the variability among programs and the universe of applicants and their readiness to move forward and hopefully encourage that effort.
Thank you. Appreciate that. Any questions or comments?
No questions. I mean, I think Vic stated it very well, and I'm sure the executive director staff would agree that we're probably going to get there eventually, where most permits will be required to be submitted online for good reasons, for public access and for all those kind of things. But right now, just the volume, the workload that would cost us, the capabilities of us to do it or of, the regulated entities, and then the cost for them as well to do it. I'm just not sure this petition today is something we need to approve in order to get there. I mean, Vic mentioned it, and I was going to mention as well that there's already been some legislation already filed for the upcoming session to require a lot of our permits to be posted online for public access. So we're going to get there. I'm just not sure the petition request is something we need to approve and require right now.
Yeah, I agree with that. I think heading into the legislative session, we'd be wise at this point just to hang back and see what the legislature may present to us. I do agree with the petitioner, of course, that public participation in the permitting process is really critical. Also that we need to improve the availability of information. Certainly, I think posting those applications online is absolutely the way to go. I understand there are some efforts underway to do that, ongoing efforts. But again, given that our program areas are in different states of readiness, that the applicants have a variety of capabilities, and some of them lack capabilities, and being smart about how we use agency resources. I just don't want to lock us into a potentially inflexible mandatory requirement that we do that. So with all that talking, I will entertain a motion.
Okay. I move that we deny the 2 petitions for rulemaking filed on behalf of Wimberley Valley Watershed Association and adopt the executive director's proposed order with the following additions. Add an S to petition in the caption of the order, and add the following at the end of the paragraph that begins, "It is therefore ordered by the Commission. Due to the variability and readiness among the TCEQ's permit programs to make applications available electronically, and due to logistic and fiscal implications on the agency and regulated entities of all types, including small businesses, a process that can be flexible enough to take into consideration the time, resources, and outreach efforts that are necessary to make more permit applications electronically available to the public is needed prior to any initiation of rulemaking."
Motion has been made. I second it. All those in favor?
Aye.
Motion carries.
Item number 32 is the consideration of the adoption of amendments to 30 Texas Administrative Code Chapters 305, 331, and 336 related to uranium mining operations. Program staff, on behalf of the Executive Director, will present the item. We do have one individual, Ty Embry, representing the Texas Mining and Reclamation Association Uranium Committee, has requested to speak, and we'll give him that opportunity after the Executive Director.
Good morning.
Good morning. Chairman Neerman, Commissioner Lindley, General Counsel, Public Interest Counsel. I'm Bobby Janeka with the Radioactive Materials Division. With me today is Colleen Ford with the Environmental Law Division and Tony Gonzalez with the Radioactive Materials Division. The adopted rulemaking would implement a federal rule update, as well as respond to a petition filed by Lloyd Goslink on behalf of the owner-operator members of the Uranium Committee of the Texas Mining and Reclamation Association. The rulemaking would modify rules in order to fulfill the requirements of an agreement state program for in-situ uranium mining operations, and also clarify and streamline rules. The requested revisions to the Commission's rules would address requirements for both injection well permitting and radioactive materials licensing for uranium mining operations, including license amendment categories, the timing of monitor well sampling, the selection of groundwater constituents monitored during the restoration period and stability demonstration, and the timing of the submission of production area authorization amendment applications for restoration table value revisions. The proposed rules were published for comment in the July 13, 2018 issue of the Texas Register. A public hearing was offered on August 9, 2018. The comment period ended August 13, 2018. The Commission received one comment letter from the petitioner in support of the rulemaking and suggesting changes to the rulemaking. No changes were made since proposal. Staff requests approval for the adoption of amendments to Chapters 305, 331, and 336, and permission to make non-substantive corrections to the adoption package if necessary to comply with Texas Register format and style requirements. Thank you for your consideration, and we're available to answer any questions.
Thank you. I don't have any questions at this time. Commissioner Lindley?
I have one question.
Yes.
Bobby, is today your last day?
Yes, ma'am, it is.
Well, thank you for going out with a bang. Doing a rulemaking on your last day is probably not something a lot of staff experience. So thanks for sticking around and seeing it through.
Thank you.
And good luck. That's all.
Mr. Embry?
Yes, Commissioners and General Counsel and Public Interest Counsel, my name is Ty Embry. I'm here on behalf of the owner-operator, members of the Uranium Committee of the Texas Mining and Reclamation Association. It's a mouthful. Just to express our support for this rulemaking, these revised rules, and also to express our appreciation for all the hard work that the TCEQ staff has put in on this rulemaking effort. There's some things in our petition that we filed that we need to continue to work on. Not everything is in the proposed rules, and those are issues we look forward to working with y'all, with the commissioners and the staff to continue to work on those. But we think the proposed rules revisions will move the industry forward. And really, like I said, just appreciate all the hard work that's gone into this rule package. So thank you.
Thank you, Mr. Embry. Any questions?
No, sir.
Okay. Thank you.
Thank you.
Mr. McWhorter?
OPIC recommends adoption of the amended sections of the Commission's Chapter 305, 331, and 336 rules as presented by the Executive Director.
Yeah, I think it's appropriate that we move ahead too. I think we've succeeded in the goals of improving clarity and reducing burdens while maintaining protectiveness. So I'm prepared
Ready
to
for a
entertain
motion?
a motion.
Okay. I move that we adopt the proposed amendments to 30 Texas Administrative Code Sections 305.62, 331.84, 331.107, and 336.1115 as recommended by the Executive Director.
The motion has been made. I second it. All those in favor?
Aye.
Motion carries. Thank you.
Item 33 is a consideration of approval of the recertification of the Houston-Galveston Area Emissions Reduction Credit Organization for another 12-year term. Program staff, on behalf of the Executive Director, is here to present the item. We currently don't have anyone signed in to address the Commission.
Good morning.
Good morning, Chairman, Commissioner, General Counsel, Public Interest Counsel. On behalf of the Executive Director, I'm Lindley Anderson with the Air Quality Division. With me is Amy Browning of the Environmental Law Division. For your consideration today is a petition requesting recertification of the Houston-Galveston Air Code for another 12-year term. Based on the information provided in the petition and the comments received at the public hearing, recertification of the Houston-Galveston Air Code is being recommended by ED staff. The Houston-Galveston Air Code meets the requirements of Texas Health and Safety Code, Chapter 384, and recertification is in the public interest. Staff respectfully recommends approval of the petition seeking recertification of the Houston-Galveston Air Code. Thank you for consideration of this matter. We're available for any questions.
Thank you. Any questions?
No questions.
Mr. McWhorter?
OPIC agrees with the ED and recommends approval of the recertification of the Houston-Galveston Area Emission Reduction Credit Organization for another 12-year term.
Thank you. Commissioner Lindley, I'm going to go out on a limb and go ahead and move that we approve the recertification of the Houston-Galveston Area Emission Reduction Credit Organization as recommended by the Executive Director.
I second.
Motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries.
Item number 34 is a follow-up to a former petition for rulemaking to amend 30 Texas Administrative Code Chapter 213 to enhance Edwards-Afer notices processes. Program staff on the Executive Director will present an update. We also have Nancy Hernandez, who is the original petitioner here, and would like to address the Commission at the appropriate time. With that, the Executive Director.
Good morning.
Good morning. Thanks for having us. Good morning, Commissioners, General Counsel, and Public Interest Counsel. For the record, I'm David Van Soest with the Austin and Waco Regional Offices. And with me is Ann Rustrom of the Program Support Division, Robert Sadler of the Edwards Aquifer Protection Program, and Michael Parr of the Environmental Law Division. Thank you all for having us back today to discuss the mechanisms and provide public notice and share information gathered from the annual Edwards Aquifer Program meetings that occurred in Austin and San Antonio on October 22nd and 23rd, respectively. Approximately 30 written comments written and oral comments were provided by the public, conservation districts, other state agencies, and various environmental or other local organizations. Comments ranged from various issues surrounding impacts and protection, from quarrying operations and/or sensitive features that directly impact groundwater recharge in the Edwards Aquifer, the need for more transparency and inclusion of public input in Edwards Aquifer plan approvals, the need for more outreach in local governments and community groups, requests to make geologic assessments that detail sensitive features in a given area publicly available for review, expressions of concerns of wastewater treatment plant discharges within the recharge zone and into the Edwards Aquifer, and also requests to increase conducting investigations of site best management practices during and after construction activities over the Edwards Aquifer. 8 of the comments specifically addressed public notice, requesting TCEQ make Edwards Aquifer Protection Program applications and pending permits authorizations available electronically to the agency's website. To increase program efficiency, the Edwards Aquifer Program has instituted many changes regarding its administrative and technical processes and procedures to streamline the application process, as well as make it more understandable and available on the agency's website. In keeping with the ongoing enhancements to the program and based on the review of public comments, the Executive Director has recommended procedural changes for the public notification that include the creation of a web page that contains pending Edwards Aquifer Protection Program applications and notifying interested parties by using the GovDelivery subscription email system. This webpage will be publicly available, have links to pending applications, available site-specific geologic assessments, and would also provide a link to Central Registry for current application status. Posting of applications on the Commissioner's Integrated Database was requested by the petitioner. However, currently the database does not store applications, but does contain permit status for many programs, excluding Edwards Aquifer. As an initial approach to address the concerns expressed during the public comment period, the ED recommends that the web page creation and notification through the GovDelivery subscription system will be an effective way to make the applications and their statuses available to the public. The Executive Director will continue to research the best ways to display the pending applications and application status, potentially through a map viewer or some other interface. Additionally, the Executive Director would like to continue working through the additional stakeholder comments expressed at the public hearings and make recommendations as appropriate. And we're available to answer any questions you may have.
Thank you. Questions?
Not this time.
I have a question. I'm not sure I understood that. So the plan is to create a web page that would include just the status of the pending applications, or also include the applications themselves?
It would be the applications of the applications themselves with the geologic assessments, the whole
Great.
application.
Appreciate that.
Ms. Hernandez?
All together now. And please state your name and affiliation for the record.
Good morning. My name's Nancy Hernandez. I'm an individual and resident in far west Travis County and the rural petitioner, along with the encouragement of many residents. On behalf of myself and the people that I was involved with the petition, we want to thank you for your generous response to taking this very seriously and asking the Edwards team to take a deep dive into figuring out some solutions to getting the information available to the public and putting transparency in the process. I do appreciate everything that's being done so far. While the petition was declined, the actions being taken, I'm happy to hear what's going on and look forward to progress in this matter. Let me read my notes. I also wanted to mention that the TCEQ is a big and powerful organization, and while it appears monolithic and perhaps intimidating from afar, I've found it very approachable, and I wanted to just comment that the staff and the commission have been very positive to our requests. So I just want to thank you for all of that. And I'd like to also comment and make some personal acknowledgments to the Edwards team and Robert thank you very much, and to Bo Sloan and to Leah Wallen for my original open records request, and Michael Parr and Tricia Duran for her assistance. Sorry to get sidetracked on that. Everyone's been very helpful. I hope the solutions made public will be easily accessible, and the changes will hopefully allow the public to have the digital access we need, and other positive outcomes will come. And I just wanted to thank you all for everything you're doing to try to resolve these matters. Thank you.
Thank you, Ms. Hernandez. And as you've experienced firsthand, we have an excellent staff, and I don't brag on them nearly as often as I could or should. I'm just really pleased with their efforts across all different program areas. I also want to thank you for your petition and your participation in this. I think it helped move us along in a very positive and probably necessary direction. And I guess I'd ask you to just stay plugged in and make sure that we're making progress and meeting milestones, because we depend on all of our stakeholders. And I really appreciate you being here.
Thank you very much. I think it will have a positive outcome on future, everything going on in the future, because the environment is being so radically impacted by the profound development that's going on, and having access like this will really help us all protect the environment and the water. Thank you.
Thanks for your comments.
Yes, thank you for coming.
Mr. McWhorter, any observations?
I think this is very timely that this item comes on the same agenda as our prior discussion, and I applaud the effort of the ED in making procedural changes to help advance the availability of applications to the public, and I think it's a great step, and I support it.
Thank you for that. No action is necessary on this item, so.
Item 35 is the public comment session. We currently don't have anyone signed in availing themselves of that opportunity. So with that, will take us to our executive session. The commission will meet in closed session in Building E, Room 211S, as permitted by the Texas Open Meetings Act, including Government Code Sections 551.071 and 551.074, to take up and consider matters posted and noticed as items 36 through 39.
With that, we stand in recess.
time is 11:12. The commission met in closed session to take up items posted in notice as items 36 through 39. There will be no action taken by the commission as a result of that meeting. This agenda meeting stands adjourned at 11:13.